3, 2, 1, ready, start. The state government has not conferred any power of eviction on the tribunal or the district magistrate in the Act nor in the rules, and moreover, no such powers can be deciphered from the comprehensive action plan framed by the state government under Section 22(2) of the Act of 2007. Stop, hence, inferring that the power to pass an order of eviction has been vested in the maintenance tribunal or appellate tribunal or the district magistrate as implicit powers to further the objects of the Act of 2007 may not be an appropriate conclusion. Stop, para. Submissions on behalf of the members of the bar, Sri Apurva Tiwari, Learned Counsel and member of the bar, assisted the court, and he submitted that a tribunal constituted under a particular act is bound to exercise its duties within the four corners of the Act itself. Top, the tribunal as created by the Act of 2007 does not partake or assume the nature or the role of a court of law, which are constituted either under Article 214 for the High Courts or Article 124 for the Supreme Court of the Constitution of India, or civil courts constituted under the Bengal, Agra and Assam Act, 1887, or under the Civil Courts Act of the respective state. Stop. A tribunal does not possess inherent powers, which otherwise may be available with a court constituted under the Constitution of India or under any other act which specifically confers such powers upon a court or tribunal. Stop. It was further submitted that the Act of 2007, does not confer any power of eviction either on the tribunal or the appellate authority, since the Act of 2007 is a special act, hence, its provisions have to be construed by taking aid of the provisions in the Act itself, and external aids may not be borrowed for the said purpose. Stop. While considering any provision of the Act of 2007, the definition given in the Act itself can be looked into, and it would not be appropriate to ascribe a particular meaning or import some powers for the purpose of the Act of 2007 by borrowing it from any other act or rule. Stop. Para. It was urged that apart from Section 23 of the Act of 2007, though for a limited purpose, there is no indication that the tribunal constituted under the Act of 2007 has been conferred with powers to order eviction. Stop. Since the provision of appeal has been couched in a restrictive language permitting an appeal under the Act of 2007, only at the behest of the senior citizen oblique parent and not at the behest of an aggrieved party. Hence, the appellate authority would also exercise restrictive powers, that is to say, it cannot exercise powers and pass such orders which the tribunal in the first instance has not been conferred or entitled to pass. In case where relief has been claimed by a senior citizen of the parent in the terms of Section 23 of the Act of 2007, which, if dismissed by the tribunal and is appealed only in such a case where the appellate authority comes to the conclusion that the order of the tribunal relating to the relief in Section 23 has been unjustly denied, it may then, while allowing the appeal, pass such order of restoring the possession in a limited scenario, but not otherwise. Para. It was further urged that the Act of 2007 is a socio-beneficial act for the parents and senior citizens, hence the provisions have to be construed in a manner as expressed in the Act itself. In case any power which has not been conferred by the Act or the rules framed thereunder, then it may not necessarily permit the Constitutional Court to take recourse to powers of interpretation to read such powers into the Act which was left out by the legislature itself while promulgating the special law. Para. It was further urged that it is true that beneficial welfare legislation deserves liberal interpretation, but at the same time it is to be seen that liberal interpretation may not give rise to any anomalous situation, as such an interpretation would not be desirable. It was further submitted that if an act confers powers to do certain acts in a particular manner, then such acts have to be done in that manner alone and not otherwise. Since the power of eviction has not been specifically provided in the Act of 2007 nor in the rules of 2014, hence, such powers cannot be exercised by the tribunal, appellate tribunal or the district magistrate. Thus, the view expressed by the division bench in Shivani Verma (Supra) may not be in consonance with the provisions of the Act of 2007 and the rules of 2014. It was also submitted that even though Section 27 of the Act of 2007 bars the